One today. Um, and I hope everybody enjoys the CLE and takes something away from it. I'm Craig Silverman. I'm a partner at Sullivan Papain in New York City. I'm here with Rich Lankoff, Downey and Lankoff, a fellow JINLAW board member. And we have two great presenters today to talk about the current state of anti-Semitism in schools and universities around the country, which has been a prominent issue in the news for over a year, maybe about 2 years now. We have Paul Eccles with us, who's a senior trial litigator at the Brandeis Center, whose mission is to support human rights and promote justice for all, including specifically Jewish people around the country. And we have Corey Rothbart, who's a litigator from Mazie Slater and Katz in New Jersey, who specifically, among other things, personal injury, med mal, handles civil rights cases and is one of about 3% of litigators in New Jersey who is certified as a civil trial litigator. So we're very happy to have these panelists with us today. I know this is an important topic to everybody and hits home for people with kids in school or kids on their way to school. So, without further ado, I'm going to pass it over to Paul and Corey, and we're going to look at anti-Semitism issues in school through a legal lens rather than the social lens that we generally hear about it. Thanks, guys.
Thanks, Craig. I'll just highlight a few high-profile cases, and then we can get into the discussion. But there is unfortunately a lot of litigation going on right now combating anti-Semitism. Here at the Brandeis Center, we're working on cases against MIT, UC Berkeley. We actually have a couple of cases against Berkeley, Stanford. We had a case against Harvard last year. There's other major cases out there against George Washington, Carnegie Mellon, Cooper Union. There's a major case settled against UCLA, and that's just actual litigation. There are a ton more that are being investigated by the Department of Education, and there's schools being investigated by HHS, EEOC, DOJ in this space. So there's a lot going on. Let me just start by giving some historical context to anti-Semitism in the U.S. educational system. There's unfortunately a long history of anti-Semitism in U.S. schools, although the form it takes has changed a bit over time. Early in the 20th century, there were bans or quotas on Jewish students at many universities, including prestigious universities like in the Ivy League. As racism in general, I think, became less acceptable, those generally fell by the wayside. And post World War II, certainly when the Holocaust was still fresh in everyone's mind, there was a period of time where I think it was thought that anti-Semitism in the US, and certainly in the US educational system, was no longer a major issue. And to the extent it was generally seen as an issue on the far right, dealing with white nationalists and neo-Nazi types. But over the last few decades, a new form of anti-Semitism has emerged, first sort of in the background, but now since October 7 has become, much more visible, where hatred of Jews and Israelis has been recast not as a type of prejudice, but more as virtue or solidarity with the Palestinian people. And along with this, there's been a new academic framework that has been created called settler colonialism that attempts to neatly divide the world into oppressors and oppressed, and squarely places Jews on the wrong side of that divide. And the problem is not just on the college level, although I think that's where a lot of the public attention has been focused, but it's also a major issue in our K through 12 school systems where teachers and some school districts are incorporating this settler colonialism type theory into their curriculums and actually indoctrinating young kids at their most formative ages with prejudices against Jews and Israelis. And you can see this in the data. The Anti-Defamation League does a great job of tracking trends and collecting data relating to anti-Semitism. So if you're ever in the need of some statistics, I encourage you to check out their website. But the increase in anti-Semitism incidents post October 7 is staggering. The 83% of Jewish college students have experienced or witnessed anti-Semitism on their campuses since the October 7 attack. Even a majority of non-Jewish students have reported witnessing anti-Semitism. Anecdotally, here at the Brandeis Center, we receive literally dozens of inquiries and complaints from students and parents every single week. And this new anti-Semitism takes many different forms. It's every time you think you've seen it all, you get some new complaint. But in terms of broad categories, verbal harassment, exclusion, ostracizing students, vandalism and graffiti on school property, litmus tests in terms of joining organizations on campuses, doxing of students, discrimination against students, boycotts and discrimination against faculty and visiting professors from Israel, threats, and so it runs the entire gamut. And again, a lot of attention has been paid toward what is going on at the major university levels with encampments and protests that have hinged into the violent. We've all seen what's happened on the UCLA campus, Columbia campus, and but one thing I really want to highlight is that there's a major problem at the K through 12 level as well. Again, where kids are actually being indoctrinated with anti-Semitic beliefs, being taught that this is what's right, and it leads to some just absolutely inconceivable stories and incidents that we hear here at the Brandeis Center. We're working on a matter at a Massachusetts public school where kids were making Nazi salutes in the hallway and naming their teams at recess, Team Auschwitz and Team Hamas. We're working on matters where Jewish kids have been taunted with the oven is that way, or go back to the gas chamber, or students are being called dirty Jew or filthy Jew, or other slurs that are even worse. We have one client who went home and told his parents he wished he wasn't Jewish because people don't like Jews. And you might think that when stuff like this happens, that as inconceivable as these things are, that schools will quickly address them. But that's not what's happening in a lot of schools. These problems drag on for years, and too often the solution is to just transfer the kid to a different class, or to even tell the parents that maybe you ought to consider homeschooling your kids. So one thing that we focus on here at the Brandeis Center is defining anti-Semitism, because without a definition, it's hard to address the problem, especially when the people in the wrong actually view themselves as being in the right. So it's key in getting effective remediation to actually define the problem and what's acceptable and what's not. And the gold standard for a definition of anti-Semitism is what's known as the IHRA definition. IHRA stands for International Holocaust Remembrance Alliance. It's a definition that's been around since 2016. It's the definition used by the US government, by dozens of other governments, states, municipalities, public and private universities. In terms of US enforcement, it was first adopted by the Trump administration during his first administration, but it was expressly retained and endorsed by President Biden during his administration, and Trump has re-endorsed it with another executive order during his current administration. And I'm not going to read the whole thing because it's quite long, but includes a number of examples to illustrate its principles. And the core definition, which I will read, is that anti-Semitism is a certain perception of Jews, which may be expressed as hatred toward Jews, rhetorical and physical manifestations of anti-Semitism are directed toward Jewish or non-Jewish individuals and or their property, toward Jewish community, institutions, and religious facilities. If you follow this issue, there's some debate publicly about the IHRA definition and pushback by some who allege that the definition is used to prevent criticism of Israel. And we believe that that is fundamentally misguided. There's a phrase right in the prefatory statement of the definition making clear that criticism of Israel, tantamount to criticism of any other state, is not anti-Semitic, that criticism of Israel only crosses the line into anti-Semitism when it's based on anti-Semitic tropes or calls for the destruction of the Jewish state and the Jewish people, where that applies double standards to the statement of Israel. So again, we think that it's critical that universities, governments, everyone with an enforcement role use a definition like the IHRA definition to make clear what's acceptable and what's not. Here at the Brandeis Center, as Craig said at the outset, we're basically a civil rights law firm. We do education and outreach, but we also do advocacy. We represent parents and students in prosecuting cases in front of the Department of Education, filing federal lawsuits on their behalf, representing students in internal disciplinary processes at universities, defending students in litigation where there's an anti-Semitic component. So if there's an anti-Semitism issue, we are there for students and parents.
Paul, I just
Paul,
have a quick question, if I could just jump in. Even though we've learned that people's anti-Semitism is so much more overt in the last couple of years, how much does access to technology, anonymity online, and particularly using AI, how has that led to some of these problems being more on the forefront?
Well, I think it certainly exacerbated it because there's people that can essentially hide behind a computer, and it creates a lot of ugliness that can really impact the lives of students on these campuses. We hear from students all the time about how their experiences has been impacted, that they feel they have to walk around sort of hiding and self-censoring them because of what's going on. And a lot of these universities have not been prepared and well equipped for dealing with the different forms this has taken, whether online or in the very public encampments. And one of the things that we do is trying to get clear sets of rules and guidelines for universities in terms of what's acceptable and what's not, and ensuring that they enforce those in an even-handed manner across the board.
Can I just piggyback on some things that Paul was talking about? So Paul was talking about the IRA definition in the context of schools and what the Trump administration has done and what the Biden administration reinforced. What Paul, I believe, is referring to is that there's executive orders that are in place that say that the Office of Civil Rights has to utilize the IRA definition when evaluating complaints against schools that are subject to Title VI to determine whether or not they have uh, permitted a hostile school environment or otherwise amounted to a violation under Title VI. What the effect or the import of that should be is that schools should be utilizing the IRA definition, knowing that they're going to be judged by the OCR, utilizing this definition. One of the things in some of the settlements with the Brandeis Center and some of the other civil rights organizations that has come out has been certain agreements by schools to incorporate the IRA definition. Not all of them, but there have been some. I forget which schools, but there have been some. But the argument really should be that these schools already should be training every school, every college, and every school should have some sort of student conduct discipline process and procedure. And those that are evaluating student conduct complaints or bias incidents or bullying, intimidation, harassment complaints, they should be trained. And the schools should be training these individuals on the definition of IRA because OCR is going to be evaluating them based upon the definition of IRA. So these schools really don't even need to adopt the definition. It's helpful and it makes it more explicit and there's no weaseling out of it, but they should already be bound by the IRA definition anyway, based upon two different, or rather three different administrations reinforcing this through an executive
Yeah,
order.
but I was going to say you're exactly right. And the funny thing is, there's a lot of, I think, ignorance sometimes at these universities, even within their general counsel's office, about both the IRA definition and what federal law requires. Because when we get into conversations with them about adopting and using IRA, we'll get pushback and say, "Oh no, we can't do that." And we tell them you're actually already required by law to use it, and you are certifying when you accept federal funds that you are in compliance with it, and that generally raises some eyebrows. So there is oftentimes a lot of education that's necessary when dealing with these universities.
I think, yeah, both of you are going to address this issue later, so I don't want to jump too far ahead, but how has the response been from universities across the country now that we've seen so many incidents? Are most of the universities taking a more proactive approach and addressing IRA, or do you see some latency there or a lag?
It's a mix. There is definitely pushback toward adopting it in full, and incorporating it into all the policies and places that we think they should. But there's also, I think, broad awareness that and recognition that they didn't do a good job in the immediate aftermath of October 7th, and they let things get out of hand in terms of protests and encampments. So there has been recognition that they need more consistent enforcement of their time, place, manner rules in terms of what they allow in terms of protests, that they do need some sort of trainings in their bias offices. A lot of the bias offices at these universities were built up around Title IX, which deals with sexual assault and sexual harassment. And then all of a sudden, these people with no real training on the type of bias and discrimination we're talking about here, all of a sudden had all these complaints falling in their laps. And they weren't trained in anti-Semitism or this sort of bias and harassment, didn't have experience. A lot of times, some of them, weren't particularly sympathetic with complaints from Jewish students. They aligned themselves more with the Palestinian cause. And so it's been, some real work with universities in getting them to recognize that they need real Title VI offices with people trained to deal with these issues.
They need Title VI coordinators, just like there are Title IX coordinators. There should be a Title VI coordinator at every school. And I know that one of the agreements, one of the settlements, I believe it was recent. I want to say it was with NYU. I forget which one it was, but one of the settlements was that the school will hire a Title VI coordinator.
Correct. So Title VI, we Corey started to talk about a little bit. Title VI is part of the Civil Rights Act of 1964. I think a lot of people are more familiar with Title VII of the Civil Rights of 1964, which deals with employment discrimination. Title VI is the equivalent of Title VII, dealing with programs that receive any sort of federal financial assistance. Even though one significant difference theoretically is that Title VII expressly mentions religion as a protected class. Title VI does not. It prohibits discrimination based on race, color, or national origin. But it's been interpreted for many years now as broadly, based on the national origin and race component of it, as protecting religious groups like Jews, Muslims, and Sikhs based on their shared ancestry and ethnicity. So there's no real dispute that it applies to both Jews and Israelis, and covers discrimination and harassment of them based on their identity. The Office of Civil Rights, Office for Civil Rights, referring to the Department of Education, is the agency that's responsible for enforcing Title VI against institutions that receive funding from the Department of Education. A lot of people probably don't know, but any institution, education or not, that receives federal funding of some sort is covered by Title VI. So there's actually Office for Civil Rights across the federal government and basically every agency that hands out federal funding. So there's an Office for Civil Rights in HHS, Department of Agriculture, Transportation, Labor, but there's also one specifically in the Department of Education that, again, is responsible for making sure all recipients, all educational institutions that receive federal funding, and that includes K through 12, charter schools, vocational schools, colleges and universities, anything with an educational component that receives money from the Department of Education is covered by Title VI and is within the purview of the Office for Civil Rights. And the Office for Civil Rights has the power to initiate investigations, conduct investigations, both on its own accord and in response to complaints by either individual students or organizations like the Brandeis Center that represent students, to ascertain whether universities are meeting their requirements under Title VI. And what Title VI essentially requires is there's no vicarious liability where they're automatically responsible for some student on student harassment. But what they are responsible for is when they receive notice or have actual knowledge of a problem, to take appropriate and timely steps to remedy the problem. And if they don't, they're in violation, and OCR has the ability either to initiate a revocation of funds, or more often to refer the matter to the Department of Justice to initiate an enforcement action.
Well, I have a question for you. In the Title VI context, it's Is it just based upon what the alleged victim is, what their race, color, and national origin is, or is it based upon the perception of what their race, color, national origin may be? And the reason I'm saying that is because you mentioned that there's no doubt under Title VI that Jews are a protected class, Israelis are a protected class. But what about Zionists? Are Zionists a protected class? Because that's where some of these schools are allowing. Uh, that's what the anti-Semitic conduct is being done through thinly veiled conduct directed towards Zionists. And at least, and I'll talk about it a little later, but at least under state level protections in New Jersey, under the New Jersey law against discrimination, it's you're protected if you're perceived as a member of a protected class. So you don't even need to be Jewish. If someone perceives you as Jewish, you'd actually be protected under the NJLAD. So is it the same in the context of Title VI?
It is the same, and we actually have a client who is not Jewish, who wore, I think it was a shirt that had some Jewish insignia on it, and as a result, people at his school perceived him to be Jewish and started taunting and harassing him, and so he's entitled to protection under Title VI, the same as if he was Jewish himself. And unfortunately, that we see a lot of that. And you mentioned Zionism. I mean that's, I think, another issue on top of what we're talking about is that Zionism is often used now as a sort of a code word for attacking Jewish or Israeli people. A lot of people claiming to be anti-Zionists out there who couldn't even define Zionism, but they're really just substituting the word Zionist for Jew, and that's a problem we see at universities and schools across the country.
Before we continue, just quickly, there's the CLE Act also. The CLE Act was named after a 19-year-old Lehigh University student who was raped and murdered in her campus dorm in 1986. And similar to what you heard already, it deals with, it's a federal law that requires colleges and universities who receive federal aid to report crime statistics. And it's being used in this context because there's this discussion about whether universities are actually tallying these events accurately. They have to, but Paul and Corey, there's allegations, of course, against some of these universities that they are not accurately reporting and tabulating these incidents.
We'll talk about First Amendment and some state level issues. I can move
Yeah.
on to that topic. So we started to talk about Zionism, and as I'm listening to Paul speak, discrimination against someone for being a Zionist, to me, that would be discriminating against someone based upon their thoughts and their beliefs. And that, in many ways, to me, could be a First Amendment violation or at least discrimination. If it's not explicitly discrimination against someone because they're Jewish or perceived as Jewish or because they're Israeli or perceived as Israeli, then it potentially implicates some First Amendment free speech issues, especially if it's being done by someone of a public entity. So a lot of these schools, well, let me just give you some background. Um, Paul's with Brandeis Center. I'm with the law firm of Maisie Slater, Katz and Freeman in New Jersey. We're a trial firm. And some of the cases that we have right now, we have some pending lawsuits against Rutgers on behalf of two Jewish students under the New Jersey law against discrimination for discrimination, retaliation, and hostile school environment. There's also I've consulted with a number of other Jewish persons against other schools. I'm about to file another lawsuit against another school, and I've got some other things in the works in New Jersey. So this stuff is rampant. I would emphasize this. It's not just at the big schools. I'm even more concerned, like Paul said, with K through 12, but also some of the smaller colleges, the local colleges. where I think there's big concerns that they don't get the press that some of the bigger Ivy League schools, I mean, even Rutgers has gotten some press about what's going on there. But keep an eye out and be very cognizant, especially if you have a family member, son, daughter, nephew, niece, or someone that you know is going to one of these other schools or K through 12. Be mindful about what's going on there because it may not get the level of attention that the bigger schools are getting, but there's issues there. Um, so these schools are often hiding behind First Amendment free speech protections, particularly if they're a public school, like Rutgers. Rutgers is the State University of New Jersey, so they're a public entity, and so they have to. They're bound by the First Amendment. Private schools, not so much. At the same time, as Paul mentioned, there's still time, place, manner restrictions that they are allowed to enforce, even under First Amendment. You don't just get to say and do whatever you want at any time you want and however you want. You don't get to, like what happened at Rutgers, you don't get to take over the business building during school and just start chanting and refusing to move and basically holding the building hostage. That disciplining for that is not a First Amendment violation, and the schools have an obligation to do so. But even still, there's case law out there. There's a Dear Colleague letter from 2024 from the OCR to schools telling them that the fact that harassment may involve conduct that includes speech in a public setting or speech that is also motivated by political or religious beliefs does not relieve a school of its obligation to respond under Title VI, particularly if the harassment creates a hostile environment in school for a student or students. So these schools can't just keep throwing their hands up and saying, well, First Amendment, First Amendment, First Amendment. No, it doesn't quite work like that. And the OCR has made that very clear. There's other case law that talks about, um, you know, reasonable regulations, what some things that the school can do. They can set reasonable rules for the forum of which this content can occur. For example, at Rutgers, the encampments on the New Brunswick campus happened during the finals period. Rutgers claims that they have a strict policy that uh, no events will be authorized during finals period because it's disruptive to the students. And in fact, the stated goal of the SJP and the others participating in the encampments was to disrupt finals. Did Rutgers discipline these individuals? Not to our knowledge. In fact, they rewarded them by agreeing to 8 out of their 10 demands. At the same time, Rutgers told a group of Jewish students that wanted to host a celebratory barbecue to promote Zionism at the same location, at the same time and place. You can't do it because it's during finals period. So that kind of leads me to my next point, which is schools want to hide behind First Amendment protection when it's complaints by Jewish persons, but they're not applying their policies evenly. Oftentimes, Jewish persons are being disciplined or prohibited from engaging in certain speech or certain conduct that the other side is being allowed to participate in. So there's a hypocrisy, a discrepancy as to what's occurring, um, particularly on schools. There doesn't seem to be equal rights when it comes to Jewish people or those who identify as Israeli or Zionists. Although, as we know, Zionism is ingrained within Judaism. I think 90% of Jews, 95% would probably self-identify. I think there's polls say that 95% of us would identify as Zionists. Like Paul said, most people who claim to be anti-Zionists couldn't even tell you what the definition of it is, what it means. They just think it means, genocide against Palestinians. Um, so the First Amendment argument, while it has some teeth, particularly as it relates to professors and educators, because there is academic freedom, and that does come into play, and public universities in particular are very cognizant of it, it does have its limitations. You know, a some of its limitations include that the school has a right to control or have influence over the content of the curriculum. Um, a math professor who is spouting to their class that Israel is a genocidal state, that is not, I don't believe that's protected by the First Amendment because that has nothing to do with the curriculum of which that person is being taught. Whereas there's an argument that if there's a class on Middle East policies, that perhaps they can teach something like that. I know some of the law, there was a recent decision that the Third Circuit came out that basically said the NJIT, New Jersey Institute of Technology, could not punish a professor who basically engaged in racist conduct outside of the school setting. Now, when it's inside of the school setting, that's a little bit different because the school does have some control over, particularly as an employee. And there's certain standards, there's certain requirements, excuse me, a test that has to be addressed for a public employee speech. One, the employee spoke, and it also depends whether or not the employee spoke as a citizen versus whether or not they're speaking in their capacity as an employee. Now, there's a little bit of overlap because we see a lot of these professors and faculty members and staff members doing through social media, through their personal social media. But a lot of their social media, they actually identify as being affiliated with the schools. And so there's a bit of an overlap there. So it's a murky area of law. It's not as straightforward as I think we would hope. But I do think that schools in particular are not even applying the First Amendment in an equal fashion. I'm curious if Paul has any thoughts on that issue.
Well, they're not. And I think that that is one area where we have gotten a little bit of traction with some schools recognizing that they need to have more clear rules and to enforce those rules. I mean, just to follow up on some of the things you mentioned, like, a math professor, you know, expounding on what's going on in Gaza. A lot of universities either have had or have adopted now clear rules prohibiting professors from talking about things outside the purview of the subject matter of their class. So they've been getting them to enforce it is another thing, but there are rules prohibiting professors from doing that, as well as from canceling classes to go attend a protest. A lot of universities either have or have now adopted rules on these things. It's now getting the university to actually enforce those rules.
That's a
Um,
great that's a great point. And that actually kind of leads into what I was going to talk about next, which is some state level protections. So as I mentioned, I filed lawsuits under the New Jersey law against discrimination. That is the state equivalent of Title VI. And most states, I think, have some sort of anti-discrimination law. The New Jersey LID, I think it may have been the first. And it is probably the broadest and it's the most liberally interpreted. And it's a lot more liberal than Title VI. The standard is effectively negligence. For those on this call that may deal with personal injury cases, medical malpractice, you're familiar with negligence standards. Well, Paul talked about notice. Um, then there's did you breach the duty of care? Effectively, the NJLD is very similar in terms of for a hostile school environment claim was students subject to severe or pervasive conduct because of their protected class? And then was the school effectively negligent in protecting against that or addressing that situation? Now, one way schools can try and avoid liabilities by saying, well, we have valid policies, procedures, and protocols in place to prevent against this. That's what Paul's talking about. There may be policies, procedures in place that say a math teacher can't be that say teachers have to stick to their core curriculum. You need to teach to the subject area and only the subject area. And if you go beyond that, you're in violation of of the policies. The issue then becomes when they don't enforce their policies. And throw their hands and say, well, we're not going to discipline the professor, or we're not even going to tell them to stop because we're so concerned with First Amendment concerns. Well, under the New Jersey law against discrimination, if schools are not enforcing their policies, that is a way to satisfy your burden under the hostile school environment claim. It's not enough to just have written policies, procedures, and protocols. They're as good as the paper that they're written on. They're not worth anything if they're not being enforced. And so effectively, the schools are not exercising the necessary due care if they're not actually enforcing their policies, procedures, and protocols, particularly if they're doing so in a dissimilar manner when it comes to one race, gender, class, one race, gender, national origin, or in this case, religion. And I think that's one of the big things that I've seen. Um, a disparate enforcement of their policies, procedures, and protocols. You can go look it up. One of the lawsuits I have is because a Jewish student spoke out against what he believes was anti-Semitic conduct, and the school disciplined him because he sent screenshots of two students who shared a wildly offensive video on October 12th, just 5 days after the day of 5 days after October 7th, on coincided with the Day of Rage. And these students sent an offensive video in a chat to nearly 50 students, part of the Student Bar Association. My client screenshotted this, sent it to the Jewish law students in response to an email that said, take receipts, get proof of any discriminatory conduct. And he sends an email saying, I've taken screenshots of people that are publicly supporting Hamas. The school ended up disciplining him, saying he defamed those students and finding him responsible for bullying. Um, And so that is at the same time, other students are allowed to basically get away with murder if you're criticizing Zionists, if you're targeting Jews. And that's the example of disparate treatment, um, particularly when it comes to enforcing their policies, procedures, and protocols. I mentioned the word bullying. To me, these cases and what's going on these schools is basically school bullying on steroids and in the context of of targeting Jewish people. There's even before October 7th, years before, there was a big, there's been a lot of talk and a lot of issues related to school bullying, cyberbullying, school bullying, a lot of unfortunate cases, kids committing suicide because they've been bullied. It's terrible. And a lot of states, including New Jersey, have implemented laws. New Jersey has the Anti-Bullying Rights Act that's applicable to schools. And so effectively what is happening on schools is Jewish students are being bullied. They're being bullied by fellow students, and the schools have obligations to protect against that. And so I would encourage anyone, if you know someone, if you know a student, you know someone that is being subjected to this, take a look at what the state laws are on anti-bullying rights, on anti-bullying, and if there's a similar act like the Anti-Bullying Rights Act in New Jersey, because that may be helpful, and it may also help identify what the school's obligations are to address school bullying. I mean, that is effectively how I viewed these Rutgers cases before we filed them. I thought to myself, this is really just school bullying, on steroids on a national level. Um,
So, Corey, let me ask you, there's a bullet at the bottom of the slide that had to do with remedies available. Can you speak to that? Are there certain steps that have to be taken, almost like we see with certain types of cases, administrative um, agencies that have to be gone through, internal processes? And what's been most successful in your mind? What can people do to combat this sort of situation when it's specific to them?
not there's no precursor to filing a lawsuit under New Jersey law against discrimination. There's no tort claim notice that has to be served. There's no administrative remedy that has to be served. You can just file a lawsuit right away. I'm not sure if it works that way for Title VI. I haven't filed a lawsuit on Title VI, although I don't believe it does.
Yeah.
I know in the employment context, it's a little bit different, but even in New Jersey, if you're going to file a lawsuit for an employee under the New Jersey law against discrimination, you don't need to file some sort of administrative relief. What type of remedies are available? Money. So the big thing about the New Jersey law against discrimination is it's a fee shifting statute. So if you win, you get attorney's fees, which is a big impetus because a lot of times the damages aren't necessarily, it's not like in a personal injury case where someone suffers an injury and fractures their leg, has surgery, or they lose a leg. There's not physical injuries often. There's more emotional damages. You can get emotional compensatory damages through an NJLAD case, but you also get attorney's fees. So the more work they make you do on the case, the more you can actually increase the value of your case. You can also get equitable reforms. I've researched this. There are equitable reforms that the court can administer if you are successful in proving your claims. There's not a lot of guidance on what the court can implement that I've seen. And in fact, I just filed a motion to amend one of my complaints to make it very clear that we are seeking equitable remedies. that will serve to benefit Jewish students and protect Jewish students.
And let me just follow up on that on the Title VI side. There is a 180-day statute of limitations to file an administrative complaint with the Department of Education. So it is a quick turnaround for an administrative complaint. But that's still, even if you miss the 180 days, you can still bring a federal lawsuit, and you don't have to file with the Department of Education. It's not like Title VII where you need to get a right to sue letter before you can bring a federal case. And for Title VI, the remedies, I think, are very, very similar. I mean, in our cases, what we are generally seeking is injunctive relief, systemic relief, forcing the universities to adopt the right types of policies, and enforce them in an even-handed manner. But there also are damages available, both compensatory damages and attorney's fees for successful litigants.
Oh, I want to let me on this note, let me address Rich's um, question as well as to what can be done or what should be doing. Look, students, if a student has, I tell students this all the time, if you have been subject to a some sort of discriminatory conduct or something that violates the student code of conduct, or you think it does, or a bias incident, every school should have in place a formal process for reporting complaints, whether it's against another student, whether it's against um, a student organization, or whether it's against a faculty or employment member, a faculty or staff member. A lot of these forms are available online. In fact, I'm actually part of the Jewish Bar Association in New Jersey, and one of the things our advocacy committee did was we put together a resource guide for all the schools in New Jersey for students and um, where they can report issues, particularly bias incidents or student conduct complaints, because almost all of these schools have these forms available online. And if you just look up a school, look up just an example, NYU student conduct complaint or bias incident complaint, you should be able to find exactly the form. But at least in New Jersey, if anyone needs it, we have a student resource guide for all of the schools. I'm happy to circulate that. And part of our goal is we're trying to build it on a national level, but that's a next step. But I would encourage you, if you know someone, or you have a client, or you know someone who believe they've been a victim, file it with the school, document it, and don't just write. Don't give as much information as you can. Attach civics, attach photos, videos, any text message, screenshots. Attach all the exhibits. Give the school everything. So then even if they don't do what they're supposed to do, then you can show that they had all the information. They can't hide behind well, we didn't know about this. We didn't have the information. And so that it builds up and so that their records build up. So if a lawsuit gets filed down the road, whether it's by your client or someone else, there's now a record of this. And this can all be discovered, and it can be utilized to show that that school is not complying with their policies, procedures, and protocols, or they're acting in a discriminatory fashion or retaliatory fashion of some way. So document it. Don't. I've heard this from students. They will say they are dissuaded because they're like, nothing's going to come of it. The school's not going to do anything about it. Well, guess what? That's what the school wants. The school wants you to feel dissuaded and not bother them and file complaints and make them do work. So the worst thing you can do is to be silent about it. File the complaints, make it a part of the school's record. So when an attorney asks for a discovery, or when a congressional committee subpoenas it or demands it as part of their investigations, it's there.
And just to follow up on that, and I think we're going to touch on this on the next slide under defenses, but one of the core defenses that schools and universities have in Title VI cases is, well, we didn't know, or we didn't get timely notice, we didn't have actual knowledge, or we sort of knew, but we didn't realize it was still going on. So in terms of being able to successfully prosecute a claim in court, knowledge and notice that's documented to the school is a critical part of any case.
I think
Um,
we're Rich. I think we only have 10 minutes left. Do you want to just maybe just skip to any questions and answers, or you want us to keep just talking? I think we kind of talked about some of this stuff already.
Yeah, I think you've gone over some of the examples without maybe being too specific. And you definitely gave some practical guidance for individuals in the situation. Maybe if you want to touch on some guidance or strategy for helping Jews on campus in this situation and lawyers representing them.
Look to don't just think about Title VI, look to the state laws. I tell this to a lot of attorneys, look to your state laws and see if there's an equivalent to the New Jersey law against discrimination. Because I don't know about other states, but there are other states with anti-discrimination laws that may be helpful and may be better resources than Title VI. Our lawsuits, we didn't file in federal court. We didn't assert Title VI claims. We only asserted claims under the New Jersey law against discrimination, and we filed in state court.
I think you mentioned earlier, the need to make lodge a complaint so the school's on notice, so it's part of discovery or congressional record. But one of the major reasons I'm sure students have concerns about doing so is retaliation. What have you seen in that regard from schools?
I've seen it. I know it was in the congressional report. I know a student who filed a complaint for something that happened in the classroom, and that student ended up being disciplined. I have some more knowledge about than is public, so I can't talk about it. But yes, there is the potential for retaliation. All I can tell students is, or even employees, faculty, or staff members that might consult, um, all I can tell them is that you're protected. You are protected under the New Jersey law against discrimination from retaliation. Now, that doesn't mean that they won't retaliate against you. There's nothing anyone can do to prevent them from retaliating against you. But you're coming to me and you're saying you've been a victim of anti-Semitism, and your concern is about future anti-Semitism. Well, if you don't do anything about it, you're sending a message anyway to the abuser, to the perpetrator, that you can get away with this because you're afraid of what might come after that. And so it's not easy to file a complaint, but you can do so. If they're a student, their complaints should be protected by FERPA. Um, so it doesn't mean their identities necessarily, but their information should be protected by FERPA in terms of that information becoming public. Um, of course, if you've engaged in public conduct, it doesn't prevent anyone from, disclosing your conduct that you put out there to the rest of the world. You post a social media message, you send a text message, that's one thing. But just by filing a complaint with the schools that becomes part of your student file and it's protected under FERPA. So the school can't just take that and go send it off to some news publication or something like that. Nor are they going to want to do that anyway. Um, but
yeah.
look, there's obviously concerns about potential retaliation. There's no guarantees against it other than saying, look, if they retaliate against you, now you may have a claim, a separate and additional claim.
Yeah, I'll just add that Corey is absolutely right. It's a real concern. It happens in multiple of our cases, in addition to our, main discrimination and harassment claim. We also have a separate retaliation claim on top of that. So it is an independent additional cause of action. And it's really all the more reason why it is so critical and important to document your complaints. Because when you go on record and document it, that's what legally protects you from retaliation, is having made a formal complaint that's going to be part of the record.
Let,
Uh,
let me let, let me say this, Paul. I'm sorry to cut you off. There's front of time. The retaliation doesn't just come from the schools. The retaliation comes from the perpetrators.
yeah,
The
absolutely.
perpetrators are, if you complain about them engaging in anti-Semitic conduct and conduct that violates the school policies, they might file, I've seen this, they will file a complaint back against you and say you've done something wrong. It's a means of intimidation. It's a
Yeah,
violation. It should be a violation of school policies to utilize the disciplinary process for abusive manners and for retaliatory purposes. And then if the school doesn't properly address that and allows the perpetrators to just file frivolous complaints, then now they may be on the hook and they may be liable. At the same time, this might also be a way to demonstrate that the schools are not enforcing their policies, procedures, and protocols in a consistent manner. If they end up punishing you, punishing that student, and not punishing the perpetrator of the anti-Semitic act. So it's a real concern, but those are just some things to be considerate of. Sorry, Phil.
Yeah.
No, I agree 100% with everything you said. And we've got students we represent that have had that happen to them, where they get retaliated against within the disciplinary process itself, and view both the other students and the bias office themselves as part of the problem. But I think it's all the more, we're wrapping up, why I strongly advise, anyone who's listening, if you know someone who has a problem, has a question, to really get some professional advice, because you want to take timely steps to protect yourself, and there are legal remedies out there.
Before we close, I know we are wrapping up. I think we have a couple minutes. What is your kind of guidance or suggestion as far as involving law enforcement? Is there a criminal aspect that comes with the nature of some of these activities? And does it make sense to involve law enforcement? And have they been receptive?
We have had matters where we've gotten law enforcement involved. I mean, some universities have their own um, police forces on campus that are involved and should be involved. And part of what we engage with in universities is making sure they've got clear rules of engagement. Because we've heard from a lot of police forces that the perception was that we were not supposed to get involved. We were supposed to let the student affairs handle it, but they don't even intercede to get the identities of perpetrators. So I think it's important for schools to have clear guidance on what their own police forces should be doing. But there are also absolutely times when it makes sense to get the outside law enforcement involved when there's been actual violence, threats of violence. I've had issues of like hacking of cyber attacks on students. So there are a lot of issues where it makes sense to actually get law enforcement involved.
Yeah, if there's some sort of violent act, just go right to the police. You can always file a student conduct complaint or bias incident report afterwards. Go right to the police.
Well, that's our time. Appreciate everyone's participation, and big thanks to our panelists, Corey and Paul and Craig as well. And we want to thank everyone at JINLAW who put this and other excellent content on. If you're not a member of JINLAW, we would love you to join. You will gain the benefit of content like this and great advocacy for this important cause, and also great networking. We've got lots of in-person events coming up. Check out our website, and follow us on social media. And again, thanks everyone, and thanks to Christina behind the scenes for helping us put all this together.
Thanks, Rich.
Thanks, everyone. Thanks for having me,
Great.
Rich.
Thank you,
Greg.
Paul, Corey, Rich. Thank you.